So, in the theme of done is better, tonight you asked and we're providing, okay? Most calls that we get about what can I do and what can I do are on pets, and they're on advertising. So now you got your advertising clue, okay? So you are here to listen to the experts on this. These are the ones that train the testers. These are the ones that let you know what needs to be done. So again, don't you want to save what you already have in rentals? Sure you do. So please welcome Logan from Fair Housing.
All right, sweet. Can everybody hear me? Okay, so I'm Logan Taylor Thompson. I'm from the Fair Housing Center. I've been working for the Fair Housing Center for about 2 years now. Before that, I worked for Detroit City Council's president. So I've been in public policy and advocacy for about 4 years now. So we've got a lot of information. We'll get through it. So just a little bit about the Fair Housing Center. Our mission is to expand or promote housing choice, the creation of inclusive communities, and work to protect and expand fair housing rights in our communities. We do this through a couple different avenues. We have our enforcement team that's complaint investigation, litigation, and research. There are a lot of fair housing organizations in the country that are litigate first and then educate. We take the opposite approach. We would rather educate landlords and property owners rather than sue them, because if you've ever been sued, you know that litigation is very, very expensive. And it's not just expensive for you, it's expensive for us as well. So we prefer to educate before litigate, which is our second bullet point. We have advocacy for anti-discriminatory housing policies. So one of the ones that Anna talked about, the lead ordinance, our CEO and general counsel helped write that. So whether you think that's a good thing or a bad thing. But, and that one's super important because does anybody know how many children in Toledo tested positive for lead last year? Any guesses? It was about 3,000. Just over 3,000 children who had not tested positive for lead the year before. So about 3,000 children every year are testing positive for lead in Toledo. Every single zip code in Toledo is high risk for lead. We also help enable our local governments to fulfill their fair housing requirements. We do this with the City of Toledo. Every 5 years, under the Affirmatively Furthering Fair Housing Amendment, they have to provide an analysis of impediments to fair housing choice, and they contract us to write that for them. So just a little bit about our history. I'm not going to read all of this. We were founded in 1975. We're coming up on our 50th year anniversary. We were founded because there was a couple who was moving to Toledo. They wanted a house with architectural integrity. They wanted a diverse neighborhood. Back in 1975, that was the Old West End. They asked about the Old West End. Their realtor told them, sorry, I don't sell in that neighborhood. They ditched the realtor, bought a house in the Old West End, started the Fair Housing Center. Let me just get that slide right now. So the term fair housing is the freedom of housing choice, the right and the ability to choose where one wants to live. Housing discrimination is denying or limiting that housing choice or treating someone unfairly because of their protected class status. And we do cover all facets of the housing market. A lot of people think that we just cover like rentals and sales, but we don't. We cover lending. A big thing right now is appraisals. I'm sure a lot of you heard about the case out in California. If you haven't, quick summary of it is there was a black family. They put their home up for sale. It appraised for about $800,000. They thought, man, this is low. They had their white neighbor step in. They whitewashed their house, had their neighbor put up pictures of their family, had another appraiser come back. It appraised for $1.3 million. So we do cover appraisal. We cover insurance, design and construction, and advertising. When there's new construction in the area, we'll go out and test it. We'll go out there with rulers, tape measures, measure slopes, measure curb heights, all of that to make sure that they're not only fair housing compliant, but also ADA compliant. So Civil Rights Acts, we have three main ones in the 1960s. The first one is just 1964, and that prohibited racial discrimination in schools, the workplace, and other public accommodations. The Voting Rights Act passed in 1965, and then the Civil Rights Act of 1968, that's the Fair Housing Act, and that prohibits discrimination in the sale, rental, well, all facets. Initially, it was based on race, religion, and national origin. 1974, gender got added, which is now sex. And then disability and families with children were added in 1988. Again, the Fair Housing Act works to expand equal housing opportunities to all persons regardless of that protected class status. Everybody's a member of protected class, whether you know it or not. It promotes integrated living patterns, and it overcomes historic patterns of segregation. So anybody can be protected under the Fair Housing Act. So anyone who claims to have been injured by an act, believe that a person will be injured by an act. And person in the legal sense includes individuals, government entities, corporations, and housing professionals. So if you're ever selling a house and the other realtor, you hear them say something explicitly racist, explicitly sexist, anything like that, you're a witness to discrimination. You can come to us, you can file a complaint against that realtor, or if it ever happens to you. So there are some exemptions to the Fair Housing Act. I'm going to go over them. The first two, it's important to note, do not apply in the state of Ohio. The first one is known as Miss Murphy's Law, and it varies state by state. I believe Michigan is 3 or fewer units, but it's an owner-occupied building with 4 or fewer rental units. Ohio does not have this exemption, so if you live in a quadplex or a duplex, you can't discriminate in the state of Ohio. If you were up in Michigan and you have a triplex and you're living there, you could intentionally discriminate for who you want living there with you. Yeah.
Could you just expand on that? You're saying if you live in it, like I could say I have a 4-unit and I live in one,
Yes.
they cannot call it discrimination?
So they can if your advertising is discriminatory. But the purpose of it is if you were living there and say you don't want children with you, you don't want to hear the noise, whatever it may be, you can choose not to rent to families with children. Yeah, but not in Ohio. If you live in a duplex or anything in Ohio, tough luck. Second one is single-family housing rented without the use of advertising or without a real estate broker, as long as the landlord owns no more than 3 such homes at any one time. Does not apply in Ohio. The third one does apply, and that's certain types of housing that are operated by like religious organizations or private clubs that limit occupancy to their own members. The second that they start letting in other members, they lose that exemption. None of those are exempt from discriminatory advertising practices, so that 150-word list that you just got, it's a good referral. That is not all-encompassing. There's more than 150 words that you can't say in your advertising. Then we've got HOPA properties. I don't know if anybody here has HOPA properties. Housing for older persons. If you ever want to get like a complex and make it a HOPA property, my recommendation would just be 62 and up. It's way easier because in 55 and up communities, it can still say senior living, but only one person in 80% of the units has to be 55 and up. People under 55 can live in 55 and up communities. In 62 and up communities, it's only 62 and up. So if you ever decide that you want to do a HOPA property, just do 62 and up. It's easier.
Please wait for the microphone or write your questions down. Would you prefer that we wait?
I don't care.
I'm asking him, I'm not asking this question.
No, before I got into public policy, I was also a teacher, so I have no problem with people interrupting me.
So you're okay?
Yeah, I'm fine. If anybody has a question, just raise your hand. We can bring the microphone over to you. And
What was Mike's question? He didn't hear that.
yeah, can
Mike?
Okay, so the question was, can a HOPA apply to a single-family house, or does it have to be some kind of community or apartment or something like that?
it is a community. And with HOPA properties, so if you buy an apartment complex and you want to make it a HOPA property, you do have to advertise that and follow the policies and procedures that go along with that. So in 55 and up communities, you have to keep track of everybody's age, you have to keep track of their driver's license, all of that, and you have to run those reports and actually submit them to the government. Same thing in 62 and up, but it's just a lot easier in 62 and up because you don't have to do any math. Yes?
If the husband is 62 and the wife is 60, would that count as them qualifying for the HOPA?
In a 62 and up community, no. If the husband's 62, the wife is 60, and they go to apply to a 62 and up community, that leasing agent can tell them, get out, come back in 2 years.
Okay, sorry, just had a quick follow-up on that. You said it didn't apply to single-family houses, but what if you were renting by the room? So let's say you had a 4-bedroom house and you were going to rent out by the room and you only wanted seniors.
That would be a question for an attorney.
Good answer.
So then we move on to our protected classes. Federally, there are 7 protected classes, and that's race, color, national origin, religion, sex, familial status, and disability. No matter where you're at in the country, these 7 classes are protected. Ohio has military status protected. So if you have any tenants who are in the military and they receive their orders, legally you cannot charge them to break their lease. They are allowed to break that lease with no penalty. You also can't deny them just because they serve in the military. If your stance is anti-military, they have protected status. Sexual orientation and gender identity, those are Toledo and Bowling Green specific protections right now. And those are only specific in the sense that we have them in our Civil Rights Code. Right now at a federal level, those are protected under sex discrimination. So sexual orientation and gender identity are protected at a federal level. We've got source of income, which is in Toledo. House Bill 150 is currently in the Ohio House to make that into a civil rights code. And we'll talk more about that. Number 12 is immigration status. We'll talk about that a little bit later. That's more, you just can't require, if somebody comes into your property and has an accent, you can't require them to prove their status here in the country. Now, if you're just consistently applying it across the board, making them check a box, if you're collecting social security numbers for background checks, they can't provide that, well, then they fail to meet your criteria. There is a 13th one. It's this very oddball protected class. It's actually at a state level in Ohio. It's one of my favorite. It's age in lending. So a 95-year-old can go take out a 35-year mortgage. 95-year-old's not living to pay off that 35-year mortgage, but they're protected. A bank can't tell them no. So when we talk about types of discrimination, there's 2 main types. There's disparate treatment, and that's kind of what everybody thinks of when they think of discrimination. Disparate treatment is intentionally singling somebody out because of their protected class status. Now, what we run into a lot is disparate impact. Disparate impact is employing a policy or a rule that's neutral on its face, but it has a negative impact on one particular protected class. Some examples of this are minimum loan values, maximum age of housing exclusions for insurance, requiring employment history from a person who's disabled, rental discounts for church members, charging for water usage based on the number of people in the household. You're not allowed to do that. It is important to note that there are a lot more examples than this. When I first started, we found, and I'm not going to mention them or where they're at, there was a complex that said they only had 2 bedrooms, and they said no more than 2 people per bedroom. So they were essentially limiting it to 4 people in the house. Well, that disparately impacts families with more than 2 children. So we've gotten them to change that. We didn't have to sue them. We just had to tell them, like, hey, that's not okay. Because
What's discriminatory about that?
so you can only limit occupancy based on fire code. You can't limit occupancy based on bedrooms. Now, there are limits if you're working with LMHA or Section 8 properties that LMHA will put on there, but you as property owner or landlord cannot restrict how many people are living in there unless it's based on the fire code, which I could get that number. I don't know it off the top of my head.
But if you do it for your entire, everybody that looks at it, you hold that. But if you have a rule and it's applied consistently, I don't know how that'd be discriminating.
Because so these particular properties were 1,700 square feet. It's familial status discrimination. If two parents want to move in and they've got 3 kids, they're not allowed, yeah, and there's 2 bedrooms and you're only allowing 2 people per bedroom, well, that family cannot apply to that property. You're automatically excluding them. That's familial status protection. That's a violation of the Fair Housing Act.
But that is a policy for who owns a house that only have 2 per bedroom. That is a company policy.
Yeah, and you can employ any company policy that you want. That doesn't mean that it won't break the law. If I were to consistently say that I only want men living in my complex, well, that breaks the law because it's sex discrimination. Just because it's a policy doesn't mean that it's not against the law. We have a question back there.
So back on the, like, 2 heads per bed type rule, so basically they're saying that if 10 people want to move into our 2-bedroom property, that we have to let 10 people move into the property?
If it falls within fire code. And if you can get an application from every single person over the age of 18, whatever your company policy is for that, then yes.
So how do we get the fire code? Wait for the microphone. If you could repeat it.
If you are concerned about Toledo Municipal Fire Code, you can find that online. I can grab that for you when I'm back in the office tomorrow, and I can send it over to Anna if you want. I can make sure that that's there. Yes.
The question I have is this: when you said that you can't charge them for water based on number of people in the household, I'm talking about based on the number of people in the household. If you're talking about the water charge. If you have you're on the same. If you are on you only have like one water system, and you have 2, like a duplex, for example. There are 2 separate houses, and one person has a couple of children, and one is a single guy with no washer and dryer. You still have to, he has to pay the same as you have to divide it 50% because they're using an awful lot more water than he is, generally.
So for the basics of the law, unless you have firm proof that they're using more water, like a second meter, then you actually don't know that they're using more water. If you're renting to someone like my little brother who takes 3 showers a day, well, then he might be using more water than that family. Yeah, it would have to be split. You can't charge more just because there's more people living in the household.
Yeah. Okay, guys, let's let him move on and finish his presentation. So what we're going to do is have you write them down now, and then we'll do them out loud because we are streaming all over the country, guys, and they aren't hearing you. So let's get through the presentation, and then we'll do all kinds of questions.
Okay. So discrimination based on sexual orientation and gender identity, like I talked about, it's prohibited in Toledo and many municipalities and even some states across the country. It is protected at a federal level right now. There's advocacy right now to add sexual orientation and gender identity as protected classes in Ohio as their own class, along with at a national level. So because it's bundled in with a Supreme Court ruling right now, if that Supreme Court ruling ever gets overturned, then federally sexual orientation and gender identity will no longer be protected. So there's advocacy to get those as their own protected classes. It's important to note that it's not just us that will take complaints of sexual orientation and gender identity discrimination. If that does occur, HUD also takes them, and it's a lot scarier to get a phone call from HUD than it is from us. So just some examples of this: suggesting or require, and these are all real examples that we've run into, these aren't made up. Suggesting or requiring a 2-bedroom unit when a same-sex couple has requested a 1-bedroom unit. Misgendering a person, so that's using the wrong pronouns. Using dead names, it's calling a transgender person by their birth name. or requiring a person to provide additional information to verify their identity aside from what's typically requested from other applicants. It's important to note with that, that those two middle points, the misgendering a person and using a dead name, if you do it one time, that's an accident. If they correct you and you continue to do it, and you continue to do it, and you continue to do it, well, you're setting up a pattern and practice of discrimination. You will not get sued one time because you had an online form, someone put their legal first name there. They walk in, you say, hey, you must be Logan. And they say, actually, I don't go by Logan. This is my preferred name. If you continue to call that person Logan, then you get into trouble there. You do not. Once they correct you, if you continue to do it, it is a form of sex harassment. And it does violate the Fair Housing Act. But again, we look for patterns and practice with those. If you do it one time, you'll be okay. So the source of income protection in the city of Toledo. So housing providers in the city of Toledo, this does not expand outside of the city of Toledo yet, have to consider all legal, reliable sources of income such as Social Security, disability, military benefits, and housing choice vouchers. So in your advertising, you can't say no Section 8, no housing choice vouchers permitted. Tenants are still required to pay all the fees and the rent in full. And they still have to meet your eligibility criteria, which may include a proof of income. And with that, that proof of income, if your proof of income is 3 times the amount of rent, what they have to provide is 3 times the amount of their portion of the rent. So if they don't pay any rent, like if their voucher covers the entire thing, they don't have to, or you can still ask for that proof of income, but if it's 0, you know, you're going to get that reliable check every month anyway. But that doesn't mean that if you have a minimum credit score of 650 and somebody comes in and you run a credit check on them and they've got a 425, that doesn't mean you have to automatically accept them because they're failing to meet your other eligibility criteria. With it, it's provided by HUD and administered through LMHA. Recipients can choose from a selection of housing meeting that program's requirements, and if the voucher doesn't cover all of it, the recipient is responsible for the other portion of that rent. So some issues we see are inconsistent policies for tenants who are both housing choice voucher and non-housing choice voucher applicants or residents. So again, make sure your policies are consistent across the board. If you have any sort of different screening criteria, give them different services, treatment, because they're a Section 8 tenant, that could get you into some trouble. And the use of credit scores for Section 8 recipients versus not using credit scores for those who don't have Section 8. If you're going to require credit scores from Section 8 recipients, it's better to just be consistent, require credit scores from everybody. For this, it's important to note, this is not a civil rights infraction, this is a criminal offense in the city of Toledo. There are fines, it's a misdemeanor criminal offense. So the city of Toledo prosecutor will come for you. Familial status, talked a little bit about that. That's one or more individual under the age of 18 being domiciled with a parent, a person having legal custody of somebody under the 18 or the designee of such a parent or legal custodian. It also includes anyone who's pregnant, so pregnant women are protected under the Fair Housing Act with familial status discrimination, or anyone who's about to secure legal custody of somebody under the age of 18. Some examples that we have seen in Toledo of this are refusing to rent to families with children, saying like this is an adults-only property. Again, that's okay if you're a HOPA property, but you wouldn't say it's adults only, you would say this is a HOPA property, specifically for seniors. You can't dictate sleeping arrangements or require that children of opposite sex have separate bedrooms. Now, if you're working with LMHA, LMHA does have specific rules for that based on their program, but they would talk to the tenant about that, not to you. You can't limit access to amenities such as a pool, having like an adults-only swim hour because those tenants with children pay the same amount of rent for the same amenities as those tenants without children. Can't charge fees or utilities based off the number of people in a household. We talked about that. Can't prohibit tricycles, swing sets, or children playing. We see that a lot in HOAs. That one's not so much in rentals. And you can't require that families with children only live in certain areas of an apartment complex, like on the first floor. If you've got this like big complex, you can't funnel them all to the back of the complex. That's illegal. That's steering. So then we get to disability. Definition of that is an individual with physical or mental impairment that substantially limits one or more major life activities. Individuals who are regarded as having such an impairment, and individuals with a record of having an impairment. The Fair Housing Act does protect persons who are recovering from substance abuse. It recognizes that addiction is a disability. So if they are recovering from substance abuse, they are protected under the Fair Housing Act. But if they are currently engaging in the illegal use of controlled substances, the Fair Housing Act does not protect them. It also doesn't protect them if their tenancy constitutes a direct threat to the health or safety of other individuals or results in substantial physical damage to the property. And with that one, you have to have tangible evidence. You can't just say like, hey, I'm kicking them out because they're crazy and damaged my property, and then you move to a victim and then you go to court and you have no evidence. A judge is gonna throw that out. But most of the time, if somebody is living in your property and they are punching holes, ripping off baseboards, whatever it may be, and you go in and see that, you're probably gonna take pictures of it anyway. So when we get to reasonable accommodations and modifications, these are super important, and we'll talk about the numbers a little bit more in depth, but over 50% of all discrimination cases in the country are disability related. So a reasonable accommodation is a change in a rule, policy, practice, or service. So that's some examples: creating a reserved handicap parking spot, allowing an assistance animal when you have a no pets policy, or if somebody requests ground floor residence. Modifications, on the other hand, are structural changes to the premise to make it accessible. So things like adding a ramp, grab bars, widening doorways, lowered kitchen counters and cabinets, and adding levered door handles. The cost of these with accommodations, the cost is minimal. And so that's typically absorbed by the landlord or owner, right? If you've got an apartment complex and somebody wants a reserved parking spot or a handicap parking spot in front of their unit, you know, that's the cost of blue paint and a $10 sign. That's not that expensive. With modifications, on the other hand, you know, lowering kitchen counters and cabinets, that costs a lot of money. And so in private housing, which if you have private housing, if you're not subsidized housing, the tenant does bear the cost of those. So if somebody comes to you and requests a reasonable modification, and they want to take out your tub because it has a lip and they have mobility issues, and they want an accessible tub or an accessible shower, they would bear the cost of putting that in. You wouldn't have to do that. Now, if you were working in subsidized housing, or if you have subsidized housing, you do bear that cost, and that's only because the federal government gives you money to make those repairs. So the process: an individual must request a reasonable accommodation or modification. You should never infer one or suggest one on someone's behalf. Just because somebody might have a disability does not mean that they need an accommodation or modification. They might be happy with how everything is. Modification or accommodation can be requested at any time during the rental or application process, and it can be made orally or in writing. You can't force them to use certain forms or anything like that. And it can be made orally because there are disabilities where people can't see, people can't write, people have mobility issues with their fine motor skills. You can't make them write it out, because if they don't have the ability to do that, well, then you're never going to process it, which is a denial. And the purpose of it is to provide equal opportunity to the use and enjoyment of their dwelling. So here are some things that you can require or request. So a housing provider may request information in order to verify that the person has a qualifying disability, that they have a need for the accommodation, and the relationship between the person's disability and the need for the modification or accommodation. If you are requesting this, It should only be requested if the disability or the need for the accommodation or modification is not known or obvious. If somebody shows up to your property and you have a no pets policy and they have a cane, like a cane, and they've got a dog with them, and they say, hey, this is my service animal, I know you have a no pets policy, I would need them to live with me, do not request additional information. The need for that is very obvious. Verification can be provided by a medical or social service professional, family member, or any other reliable third party. And it's important to note that it's a reliable third party, right? If somebody emails you a PDF from pets.com, and this is something that we saw, emailed in a PDF from pets.com saying that they paid $100 for their emotional support animal certificate, and then sent that and the actual verification letter to their landlord, well, that's not a reliable third party. You can go back to them and say, like, hey, I know you paid for this. We need reliable information. It's also important to note that just because it comes from out of state or an out of state doctor does not mean it's not reliable. Because of the pandemic, there has been an increase in telehealth and online therapies. So somebody might be going to therapy online, seeing a doctor out in Boston. That does not mean that they have not been under the care of that doctor. So just make sure that it comes from a reliable third party. This says it's typically not appropriate. It's never appropriate to request detailed medical records or inquire about the nature of a person's disability. A doctor would never give you that. They're not risking their license to make you happy. So as a landlord, you can deny a request for a reasonable modification or accommodation if you can demonstrate that the request was not made on behalf of a person with a disability. There's no disability-related need for the accommodation. Providing the accommodation would impose an undue financial or administrative burden onto you, or if it constitutes a fundamental alteration to the services or programs provided by you as the landlord, right? If somebody comes in and they say, hey, I need a reasonable accommodation, I need you to hire somebody to clean my unit for me, I can't clean it, so you gotta take care of it. Well, that would impose an undue financial or administrative burden on you. And it also changes the policies and services that you provide to all of your other tenants. So when you do deny, or if you deny, because it's not reasonable, provider should discuss with the requester whether there's an alternative that would effectively address the requester's disability-related needs. It's known as the interactive process. We see this a lot in subsidized housing. Somebody might make a modification request for this accessible tub or accessible shower, whatever it may be, and they might submit their modification request with like a $75,000 shower. Well, that is a lot of money. So you can refuse that and say, hey, what can we do to help meet those needs? And you could say, hey, I found this $2,000 shower that meets the exact same requirements. It would meet your disability-related needs. That's known as the interactive process. Failure to reach an agreement or an undue delay in responding to a request may be considered a failure to provide a reasonable modification or accommodation. I tell this to landlords all the time. I really wish we could give you like a hard, fast date of when a delay means denial. There have been courts that have found 14 days is a denial. There have been courts that find 90 days as a denial. There's no hard, fast date for that. It really depends on what the need is. If somebody tells you that they need a service animal with them and you wait 14 days and you tell them, like, oh, hold on, you can't bring that dog in here. Well, 14 days probably would be a denial at that point because it's a very needed thing. So it's always just best to process those as fast as possible. So with assistance animals, I know it's everybody's favorite topic. Assistance animals are not, under the law, are not considered pets. You can't apply the no pets policy to them. They're akin to medical devices. Most commonly, they're cats and dogs, but they could also be birds, fish, or other small animals. If you've got a no pets policy, maybe somebody has allergies and they've got like an emotional support snake I haven't seen that, but there have been cases of that because they can't be around pet dander. That could be one of them. And the resident may need to request a reasonable accommodation and provide that verification. Again, if it's known or obvious, just go ahead and tell them they can have it. So this first slide, I've got a lot of things that you can't do. Next slide, I've got some things that you can require. So we go back and forth. So you can't apply a no pets policy to assistance animals because, again, assistance animals under the law are not pets. Can't charge pet deposits or monthly pet fees because, again, they're not pets. Can't restrict the size, type, or breed of the animal, and that sounds scary, but we'll get to it. You can't require that the animal be trained or certified because emotional support animals typically are not trained or certified in any manner. They provide emotional support to their owner. Service animals, however, are typically trained, but you can't require it. And you can't require the animal to be spayed, neutered, or declawed. Now, you can require that the tenant cares for and supervises the animal at all times, that the assistance animals do not harm or disturb other tenants, that the tenant properly cleans and disposes of animal waste, so they can't just leave a mess all over your property. The tenant does bear responsibility for damages beyond normal wear and tear, so if they have a cat and it's not declawed, and it scratches up your baseboard, scratches up all your drywall, whatever it may be, even dogs do that, so I don't know why I pick on cats, but if they're an assistance animal, destroys your property, pees everywhere, stains carpet, whatever it may be, the tenant is responsible for those damages beyond normal wear and tear. And you can take that out of the security deposit, and if that security deposit doesn't cover it, then go ahead and send them an itemized billing. And then tenants also have to follow local and state licensing and vaccination requirements that apply to that specific animal. So if somebody requires an assistance animal and it's a dog, all dogs have to be licensed with Lucas County. I think Wood County has the same thing. So after you approve that, you can request all of that information from them. You can request their vet records, you can request their licensing information from the county. You can request all of that to have on file to make sure that they're up to date with shots, because the last thing anybody wants is an animal with rabies living in their property, potentially harming somebody. So we move on to terms and conditions. Again, terms and conditions should be consistently applied to all tenants. Variations based on protected class could be discriminatory. So like we talked about, that limiting the use of pool, exercise room, or common areas. Again, if it's like an exercise room and there are laws in place like no child under 13 can be allowed because of insurance exclusions, that's different than just saying it's an adults-only swim hour. Refusing or delaying a request for maintenance because of someone's protected class is discriminatory, or charging a higher security deposit based on any sort of protected class is discriminatory. The application and screening process, again, consistent and objectively applied to everybody. Don't change anything for anyone. The criteria should be based on whether the tenant can afford the property and not pose a direct threat to the other residents or property itself. Again, just everything consistently across the board. Here are potential legitimate reasons for denial. Criminal history is first. We'll talk about that more in depth. If they have a history of property destruction, poor credit, bad checks, or the amount of income is not right. If they can't provide identification, if they have a history of disturbing their neighbors, if they're falsifying information, if they plan to use the premise for any other purpose than what it's designed for, if they fail to complete or sign documents, if they can't pay the full security deposit or rent, or if they have an eviction record. Those are all potential legitimate reasons for denial. Now, if you're only applying these to one protected class, then it's discriminatory. But if you're, again, consistent, even across the board, you'll be fine. With criminal history, HUD guidance was issued in 2016 that restricts blanket bans on criminal history. It was found to have a disparate impact, that policy or rule that's neutral on its face, but negatively harms one protected class. It was found to have a disparate impact on African American and Latino men who experience higher rates of incarceration. African American, Latino men do not commit more crimes than their counterparts. They are just arrested at and convicted at a much higher rate. HUD recommends a shorter look-back period. HUD recommends a 5-year look-back period, and there's actually new guidance out. They submitted a memo that was, I think is still open for public comment. That would reduce that further. It's also important to evaluate the nature of the offense and whether or not it has a bearing on a person's ability to follow the rules and refrain from harming the other tenants of the property. Consider individuals on a case-by-case basis and evaluate the nature and the severity of the crime, and consider the length of time that's passed since the crime was committed. Make a determination based on facts and evidence, not a perceived threat. And utilize conviction records and not arrest records as proof of offenses committed. Again, we have a great American legal system, innocent proof until guilty. When you are arrested, you are not guilty. You are suspected of a crime. When you are convicted, that's when you are guilty. So utilize conviction records. That consider on a case-by-case basis, because if you have this blanket ban, if you say, if you've committed a crime in the past 5 years, you're not allowed to live here. Right? Well, you're going to disqualify a lot of people. You should always take it on a case-by-case basis, because in Toledo, we have a college here. If somebody who's 20 years old gets a misdemeanor minor in possession, and that's on their record, and they go to rent somewhere at 24 years old, that they've graduated college, have a job, if you're just automatically denying them from a minor in possession from 4 years ago, well, that doesn't really have an impact on whether or not they have the ability to pay rent, be a good tenant, all of that. So take everything on a case-by-case basis and evaluate them. Individuals can legally be denied housing if their recent criminal history makes them dangerous and a risk to other tenants or neighbors. So if they're a violent crime, violent felon, that is a potential legitimate business reason to deny them. Or if they committed arson, which I think is a 6 to 12 month prison sentence right now in Ohio, something like that, depending on the case. So if they got out, if they committed arson, a year ago, well, that's a potential legitimate business reason to deny them. They could potentially pose a threat to your property. We'll skip over the other stuff. Skip over examples. So it's important to note, here in Toledo, we were the first ones to bring this to a federal level. We got it established in the federal level that sexual harassment does violate the Fair Housing Act. That was Shellhammer v. Llewellyn. Before that, and I believe that was in 1987, don't quote me on that. Before that, landlords could sexually harass tenants with no penalty. But since then, it does violate the Fair Housing Act. It's a form of sex discrimination that involves any sort of unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. A lot of the time what we see, and what was it, Shellhammer v. Llewellyn, was quid pro quo. It offers to exchange services, rent, repairs, etc., in exchange for sexual favors. The landlord had a lot of female tenants. He was trying to get pictures of them, trying to sleep with them in exchange for either discounted rent or they didn't have to pay that month. That's just sexual harassment. So some other types, refusal to show, sell, or rent property, or refusal to negotiate or consider an offer because of someone's protected class is discrimination. Blockbusting is persuading people to move based on fear that members of protected class are moving into an area. Redlining, refusing to sell or rent properties in certain neighborhoods. Making housing unavailable, so that's failing to provide complete or truthful information. Refusing to offer all available options, or not responding to inquiries, failing to show up to scheduled appointments. Again, patterns and practice with that. If you get into a car accident on the way to a showing, you're not going to get sued. Steering is directing buyers or renters to certain neighborhoods or areas of a complex based on their protected class status. So, like we talked about, families with children, if you're only letting them live on the first floor or in the back of the complex. Landlords are entitled to proceed with court evictions for lease violations. You have to do it in an even-handed manner. Treating people differently or more harshly because they're a member of protected class is a violation of the Fair Housing Act. But if you've got records of them breaking your lease, just constantly over and over again, obviously go ahead and move forward with that eviction. If they're breaking your lease, apply that eviction to them just like you would any other tenant. Just do it in an even-handed manner, be consistent. So the rental registry, Ohio law does require that rental properties register with the county auditor. Hopefully all of your rental properties are on there. Registration's free and easy. You can just do it right on the auditor's website. Takes 10 minutes. Doesn't take that long. So the Toledo Lead Safe Ordinance, Anna had mentioned it earlier. As of September 18th, the city of Toledo did win their court case, so the lead ordinance will be going into effect. We're just waiting on an implementation date for that law. And like I said, it's an effort to prevent lead poisoning, to make sure that homes are lead safe, because children should not be getting lead poison at the rates that they are. It applies to 1 to 4 unit residential rental properties built before 1978, because after 1978, lead paint was outlawed. It requires properties to pass the lead inspection and receive a lead safe certificate from the health department. And it's phased rollout based on census tracts. With that, I can pull up the map in a minute, but on ToledoLeadSafe.com, it has the rental registry overlaid with the census tracts, and when those properties in those census tracts have to have that certification by. Now they may push it because they may push the dates because it just got approved, so they may go on there and edit those dates. But for most of them, it's based on that census tract data, because we're looking at where children are getting lead poisoning from the most, and that's where we're basing that initial phasing and rollout on. That's just some information from their website on why it's important to be lead safe. It is important to be lead safe. It makes your property safer for potential residents and tenants. If you wouldn't want to live in your property, why would you want somebody else to live in your property? So prevention for housing discrimination, obtain regular fair housing training. That's why we're here today. Treat every application if it may be a fair housing test. Here's my one thing with that. If you ever think that you're being tested by the Fair Housing Center, I can assure you that you are not. Our testers are paid professional actors. You will never know if you are being tested. So just treat every application like it's a test. Use uniform policies, procedures, and forms. Again, just be consistent across the board. If you want to be consistently a bad landlord, that is your right to do so. If you want to fail to show up to every appointment you have, if you want to make it so that anybody who applies to your property to qualify for it has to have 8 times the amount of income, a 750 credit score, whatever it may be, it's probably not good business, but you can be a jerk to everybody if you want to, as long as you do it evenly and don't say any slurs or anything derogatory to people. With documentation, document all your policies, procedures, and actions taken to enforce your rules or enforce the lease. Make sure that that's in writing and saved as a PDF. It'll have, once you write that up, it'll have an electronic date that's stamped to it, and it'll be saved. Discuss any unusual applications, or difficult cases at staff meetings if you have staff. You're the owner, so you don't have to inform management. So here's why it's important. In 2023, there were just over 34,000 complaints of housing discrimination. That does not include all cases of housing discrimination, obviously. Most housing discrimination goes unreported because a lot of states do not have the resources. You'll see that California is this very dark purple. That does not mean California is a worse offender than some states. That just means California gives a lot more resources. California also has a lot more protected classes. Here in Ohio, we're number 2, but Ohio has more resources. We have a lot of fair housing centers for our state. Like I talked about, disability discrimination makes up almost 53% of all complaints. Race makes up about 17%, and state and local violations make up about 17% as well. That number needs to be updated. In 2023, about 83.5% of all discrimination cases come from rentals. and that's why it's important to know. Here are just some Ohio numbers. So there are almost 3,000 cases of complaints of housing discrimination in Ohio in 2023. Disability makes up about 50%, right at around national average with everything else. In the Midwest, complaints are up 12.3%. So, and again, those numbers are wrong. I need to edit that. So that's from 2022 to 2023. In the Midwest, there was about an 850 case jump from 2022 to 2023. In Ohio, there was about a 760 case jump. So just in the Midwest, that 12% increase, about 90% of that is from the state of Ohio. And Anna talked a little bit about Senate Bill 76. Again, call your representative. Please call your representatives to talk to them, because they do this with the intention of getting hedge funds out, getting out-of-state investors out of the area, letting people either buy homes and live in them, or letting local investors have an opportunity, because a lot of local investors can't compete when somebody's offering $100,000 over asking in cash. So Senate bill, there's two pieces of legislation right now aimed to preventing the out-of-state investors. Senate Bill 36 proposes that tenants of rental homes that fall into foreclosure situations receive the first rights to buy the property. And then, like Anna talked about, Senate Bill 76 is a $1,500 tax on entities that own more than 50 single or double or triple family homes in one single county. So call your representatives, because that $1,500 tax? Yeah, it's going to be the tenants. Yeah, it's going to be the tenants. Just like with the tax increases, that falls on the tenants. So yeah, go get your property values lower so we can keep rent affordable. So that's all I have. We won't get into landlord duties or anything like that. You can look up the Landlord Tenant Act. Really, all I have to say on that is you have to keep your properties in safe, habitable conditions. You can't let them fall into disrepair. If you've got mold problems, you have to remediate that mold. If you've got holes in your floors, take care of that. People can't live like that, so. Well, if you sign a 12-month lease, then, yeah, then they'll put their rent into escrow and you'll just lose out on a bunch of money.
Please bring the microphone up, Judy. Also, there's some questions. I have to admit, out of 80-some properties, I don't have any properties that are $1,500 a month, let alone to have a tax on that. So the question is here for voucher versus non-voucher, treating everybody the same. What about the fact that we have to do inspections and damage reports almost on a 9-month basis for vouchers, but we don't have to do that for non-vouchers? That's not treating equally, correct?
I mean, if that's what the law says that you have to do, then you have to follow that law. You're not treating.
That's a Section 8 law.
Yeah,
What they're talking about.
I mean, you're not treating them negatively because of that. You're just complying with the laws to allow them to keep that voucher and stay in your rental.
And this one says they did not understand your explanation of gender identity and sexual orientation. It was too confusing.
So again, if somebody comes into your property, does anybody here go by a nickname? Like named Robert, goes by Rob, something like that? What's your name? Robert. Robert? Do you go by Rob? So if Rob here came, if I was meeting him for the first time, he applied to one of my properties, I see that his name's Robert. And again, regardless of personal beliefs, and so I see Robert. I say, "Hi, Robert," and you correct me and you say, "Actually, I go by Rob. I prefer Rob." And every single time I talk to you, I say, "Hey, Robert," right? That's just kind of a rude thing to do. to anybody, regardless.
Yeah.
Again, it's a personal thing, but there are people who go through the legal process of changing their names and just haven't gotten to that point yet.
Oh.
So again, with sexual orientation and gender identity specifically, if somebody has not legally changed their name, they cannot sign their preferred name on a contract. They have to sign their legal name. That's another question that we get a lot. They have to sign their legal name on any sort of legal documents. You can require that. Just when you talk to them, be nice.
Okay, go ahead.
I have a question on that ECA. Did you say that we can't require them to be spayed or neutered?
For assistance animals, you cannot.
Okay, even if it's like a policy for us in general, we have to accept them with a unneutered cat that's going to pee all over our house?
Yep.
Like, no matter what, they get to make an exception?
Yes.
Okay, that I need to know. I did look up the fire codes for you guys on the 2 beds per head. It is 60 square foot for one person. If you've got 2 people per bed, it's 50 square feet. So any 10 by 10 room can have 2 people. So it's not like you can pack 3 or 4 people in a 10 by 10 room. So it's got to be at least 100 square foot. It's got to be at least 150 square foot for 3 people. So I'm going to change my policies just to, each one of them I have to know the square footage. It actually works out better because if you have a 9 by 5 room, you can only put 1 person in it. You can't stack 2 people in it. So that's kind of good news.
The one thing that I will say with that, be careful because they can, according to fire code, it's any habitable living space. So that includes living rooms, dining rooms, anything like that. It's any habitable
Kitchens.
living space.
Including basements?
Basements, I am not sure about because there are other requirements with basements. I believe in Ohio it has to have an 8-foot ceiling. You
Yeah.
have to have egress windows
Got to have an
to
egress
make
window.
to make it considered living space. I know, like, if you go to buy or sell a house and it has a finished basement, it's not counted in the square footage unless it meets those requirements. So,
Yeah, there was extra stuff in there. It was actually pretty easy to read, but
Yeah.
it does talk about class 1, class 2, and class 3 housing. So I just looked up class 3 for single families and apartments. The other ones are furnished, different type of stuff, so you
Yeah.
gotta look up the different classes. But it did say per bedroom, but then it does go on to say, like, even if the bedrooms are so big, there has to be so much living space, especially in class 1 and class 2. But class 3, it did say it was specific for bedroom space for multiple residents in a bedroom.
yeah.
But it was, I just searched it, it's actually an Ohio code.
Yeah. Yeah, so,
This one here says, it's not a question. I do not remember any of my residents' nickname. I have too many of them. I'm sorry. The other one says, does fair housing have a fund to pay for animal damages?
do we have a fund to pay you for animal damages?
Yeah, assistant or?
No.
Okay.
No, absolutely not. No, we run on a very tight budget. We're grant funded. We don't have all this extra money. At the beginning of the slides, it said something along the lines that we've recovered $34 million in damages. I promise you, we do not have that $34 million. It goes directly back into the community through different grants that we give out through like Habitat for Humanity for roof replacements and stuff like that.
This is a kind of a long one. I have a woman who is barely enough money to buy the family food. She wants to rent Section 8. I know the house will not pass Section 8. How do I feel good about taking her weekly food money for an application that the house is not going to pass?
I mean, I can't help you feel good about that. But again, you can't deny her from applying. Now, if you have policies like a credit score that she doesn't qualify for, then that's a legitimate reason for denial.
Wait for the microphone.
I spoke to other representatives from Fair Housing on this, to LMH. I had a woman come to me here recently. She had spent $1,200 in application fees on houses, you know. She came to me in tears because she can't get rentals. Landlords, all this law is doing is forcing, is making people lose money. Let me give you an example. If I truly didn't want any LMH properties, in my lease, it would say, all residents are responsible for LMH required repairs on the annual inspection. Guess what? LMH won't allow that lease to be signed, and that's my business policy. And that's across the board. I can do that with anything across all my leases, making tenants responsible. I'm just letting you know all this law is doing, because landlords that want LMHA, they will take it. And those that don't will find a way around it, and all it's doing is increasing the malnutrition of our most vulnerable children by taking food away from the family health budget. And I'm letting you know so that you can take that back to your organization.
Again,
It's true.
my organization does not enforce that law. That is the city of Toledo.
That's not true, because you took, your organization took me.
Where's the microphone?
Rights Commission
Give him the mic.
Toledo Fair Housing
Yes.
took me to the Ohio, first of all, I was charged for discriminatory practices regarding Section 8 and accepting applications, right? Toledo Fair Housing was more than happy to let it go away if I was willing to ante $90,000, all right? My words to George, I think his name is, was less than polite, and I won't use it with the ladies in the room here, but they started with F and ended with a U. I took it then to the Ohio Civil Rights Commission. The Ohio Civil Rights said they had commission, in their opinion, said they didn't understand why this was being brought before them because I had done nothing wrong. Now I know that, but so don't tell me that Toledo Fair Housing doesn't enforce it. You do by sending your testers in, which, by the way, in my research, Toledo Fair Housing, their training of their testers doesn't meet the national standards of the federal fair housing agencies in how they train their testers. And that's important too. You're letting people come out there. Well, I'll leave it at that because we're not done having this conversation. My attorneys and your attorneys are going to chat on this one. But yes, you or your organization does try to enforce it.
With that, I cannot personally speak on that because I don't know when that case was filed. I'm not an attorney on that case. I'm not an attorney in general. I'm our education and outreach coordinator. I don't do a whole lot of enforcement practice. But I am sorry that that happened to you. I'm sorry that you had to go to court and, you know, OCRC, found no probable cause.
Yeah. The cost to win is almost as bad as the cost to lose.
But
This is
if I can say one more point with that.
Sure.
Our testers do meet all federal requirements for testing. Our testing coordinator spends hours, like has a set amount of hours that they have to receive in federal training from HUD, and how to proceed with these tests, how to manicure them, how to make them. So they're directly getting training from HUD on how to make the tests. So it's all in alignment. We have to report every single test that we do to HUD. So if there's anything out of alignment, we would lose grant money for that because our testers are paid for with grants. So all of our practices with testers are above board.
Okay, this is a water question. You mentioned that you can't charge by household size. Can I charge a flat water fee? I think the water company has their own laws, and you need to look into those about what you can charge that isn't the actual bill. I think you have to check the water laws. Microphone.
I got a question on, you were mentioning about multifamily, not being able to tell somebody with kids they can't live in an upper unit. Now, that doesn't make much sense to me because if I rent to somebody in an upper unit where there's somebody living in the unit directly below it, and they have 3 or 4 kids running around in this 2-bedroom apartment, and the people below are gonna complain about the noise, and then I'm gonna have to evict these upper people for making undue noise that's coming down here, when I could say, hey, I have a lower unit here, I rent to kids in the lower units because that doesn't cause that problem. It's on a concrete floor they're running around versus the upstairs. It seems kind of foolish for me to be forced to rent to somebody with kids that I know the situation's not gonna work out, it never does, and then I gotta be forced to take them to court and have a move again because of a situation that I knew from my past experience wasn't gonna work, but you're telling me I have to do it and force that issue, and then after it becomes a problem, then deal with it, you know, then instead of seeing that problem before it happens and make accommodations accordingly.
Yeah, I mean, unfortunately, that's not me
You can't assume
telling
it.
you. That is, yeah, you can't assume that just because they have kids that they're going to make a bunch of noise. But again, that's not me telling you. This is the federal law. I'm just letting you know what the federal law is. And with that, I mean, you have to show them all available options. If they choose to live on the second floor, they choose to live on the second floor, and then if they're breaking the lease, give them lease violations, let them know they're breaking the lease, and if they don't make those changes, yeah, you can move to evict them.
This is about occupancy. May I charge rent for a home based on 3 people in the home, and then charge $75 more for every person over that 3, because our rent also includes all utilities? Ouch.
That one I am not sure about because there are some exemptions for that, such as like student housing that's operated by universities where they can charge by the head. I don't know if that applies to private housing though. That would be a question for one of your attorneys.
Where's the attorney? Is he still here?
Yeah, is he still here?
You said educate before you litigate. If a person files a discriminatory claim, do you, 1, talk to both sides and try to resolve, and 2, send, or do you just, or do you send in a tester?
Again, I don't work directly with the testers because that is a highly confidential process that I just, if we do end up going to court, I do not want to be subpoenaed and have to go to court, so I just keep myself out of that.
We all feel the same way.
Yeah, nobody likes going to court. I get that. With that, though, if we get a claim of discrimination, we do investigate it. Now, if it's something like a denial for a reasonable accommodation or a reasonable modification request, typically we will contact the landlord first and see if we can come to a solution together. We're not just automatically going to file.
This is on applications. Are we able to ask on our applications who will live there and their age? Yeah. That's not on my applications anymore.
Yeah.
Just because it's on your list.
Yeah, I don't know. I don't know the exact answer
you get
to
their
that. That's not a
right?
fair housing concern.
Yeah.
Which is why I don't really have an answer to that. That would be more just a general legal.
You get their
landlord-tenant.
ID, right? Oh, you're able to ask what the kids' ages are?
Yeah, I mean, if you can require identification from everybody over the age of 18, that's going to be living there. There's no issue with that. I've lived with friends before. We've rented, and all of us were required to have our ID and be on the lease. So anybody over the age of 18, you can. Again, that's not a fair housing issue, so I'm not super informed on the details.
This is on modification. Tenants pay for reasonable modifications. When they move, can you have them restore back at their cost? There
Yes.
used to be an escrow account, yeah.
Yep, you absolutely can. If a tenant wants to widen all the doorways, add a ramp, or lower your kitchen counters and cabinets to make them accessible, you can ask that they make those changes back to the original property at the end. A lot of the time when getting ramps onto houses, if you direct them to the Ability Center and say like, hey, go ask them, they have these great attachable and detachable ramps that are like 5 screws that go into the house. They make it super easy.
In the past, they've allowed the money to actually be escrowed to go back to normal. Is that still in place?
I believe so.
Okay. Can you share these slides by email? Couldn't take notes fast enough.
We typically don't share our presentations, but I can give you, my contact information's right here. If you have any questions, especially questions that I can't answer because I'm not an attorney, one of our attorneys, I can give them the question. They'll give me just a very general answer because they are not your attorneys, but they will just give general legal guidance. Again, we're not out just to get landlords. Like I said, with reasonable accommodation and modification requests.
Also realtors and contractors and notaries and
Yeah,
that'd be me.
we're not out to get anybody. We just want people to follow the law.
We must have a realtor in the room besides me because this says, I was told, if you offer a cup of coffee to one applicant and not to the next, you can get busted. Is that true? A little bit of an exaggeration.
Yeah, that's a bit of an exaggeration.
Just kind of teaches you to do the same for everybody.
Yeah, just do the same for everybody.
I prefer hot chocolate.
But yeah, and again, we look for those set patterns and practices. If every single time you're talking to a black applicant, you're not offering them a drink, but every single time you're talking to a white applicant, you are, well, that's a pattern and practice, and we will look into that to see if there's other. But again, just if you're offering drinks to one applicant, just offer them to everybody if you have them.
Yeah.
Obviously, if you run out of drinks, you run out.
Okay, this is on statistics. How can we find the statistics on the 3,000 lead cases, what the lead level was, and where they got it from?
So those are studies done by the city.
Oh, no.
Well, they're done by the city in association with like ProMedica. You can't go to ProMedica and request detailed medical records of lead levels and everything. But
well, no, not people or names or anything,
Yeah.
just the stats.
yeah, I'm sure if you called ProMedica and you got, I don't even know where you would call for that, but if you called and you could navigate through that, ProMedica could give you some detailed research specifically for what's going on through ProMedica systems. If you wanted to call like Mercy, anything like that, they could
Got to
probably
be
give you those.
online somewhere,
Yeah, it's got to be
right?
online.
Or you wouldn't have it, right?
Yeah. The numbers that I have are from the Blade. I don't know how the Blade gets their numbers, so.
This one's kind of personal.
Okay.
Okay, so it says, can we call you or Fair Housing to ask any scenarios that we are worried about and get your ideas on any potential problems?
Absolutely. Like I said, we much
And your
prefer-
number is?
Our general office number is 419-243-6163. That's wrong.
See if there's any more
This is my personal office line.
Just hold one of those up and walk around.
It goes right to my cell phone. Also, it's on the back of all of the materials that you were given. Our phone number's on there. But yeah, if you have any questions, please call in. We'd rather walk through the scenario with you, see what's going on, rather than have you accidentally break the law, you know?
And since he mentioned it, anybody that did not get the handouts, be sure you grab some before you leave. He's got a whole tub of them here for assistance animals, of course. It bites a neighbor, messes all over, is a better word, and barks all night. Can I evict? What's your lease say?
Yeah, what does your lease say about noise ordinances? What's it say about harming other tenants? If your lease says that is consistent with municipal codes for noise ordinances and
Yeah,
an
you just
animal-
can't charge. It still
Yeah.
has to do all the rest of the rules,
yeah,
right?
it still has to follow the rules of the lease. If for some reason they've got, say, this big, giant Great Pyrenees that just likes to run around the house and headbutt the walls and put a bunch of holes in the walls, well, that's damaging your property. You can enforce your lease upon them. So an assistance animal, the Fair Housing Act does not make people with assistance animals like untouchable. You are still allowed to enforce your lease just like you would anybody else.
Is it true that we can still get a hold of the Fair Housing logo and use that on all our documentations, your applications, your leases, you know, a little small version of it should be on just about everything?
Yeah, the little equal housing opportunity house.
The house with the equal sign in
Yeah,
it?
the roof with the little equal sign underneath it. That should be on all of everything that you have. If it's not, it's just a good practice to have that.
It's a
added
very
on there.
good practice to let you know you're aware and trying, especially if somebody takes your lease or your application in, it's nice that they see their logo on it. You might get that phone call instead of a letter in the mail. You can just grab it off the internet, I believe.
Yep.
I did that
Yeah, if you just look up,
22 years ago, so I'm sure it's still,
yeah,
and
if
I
you-
didn't know how to do it back then, so it's pretty easy to do.
Yeah, if you just look up like Equal Housing Opportunities logo, it'll be right there.
Okay. Did I miss any questions from anybody? Even though I changed some of your words around, I'm guilty of that. Okay, he's going to talk for a few minutes, and if you have any personal questions that you didn't want to say out loud, how about a round of applause for him sitting through us? You didn't fluster him, he isn't crying, and he isn't yelling, so we're good, right? Now, this is all certified, so you do have a certificate if you want it at the end of the room towards your professional housing provider, Ohio Professional Housing and National. Also, if you've been with us more than a year or two, you probably qualify to graduate at our big Home Depot Christmas banquet in December. So please, if you have any idea that you might be a graduate, just give me your name and we will look up your attendance records and check out all those qualifications that you've received on the 18 different topics, okay?